Hi there and welcome back. This is attorney David Drewicki from DRD Law, and today we're talking about accomplice liability, or specifically in Illinois, we call it accountability. Now, what the heck is that? It's the typical question I get when we talk about this subject because it's really not well understood and it's pretty complex as to how it can be applied and then how we argue it on the defense side of things. So we'll start with what is it and how does it apply in the defense world? And accomplice liability or accountability is where a defendant is liable for the actions of their co-defendant or somebody they were working with. Specifically, the way it's defined is under Illinois law, a person is legally accountable for the conduct of another if they solicit, aid, abet, agree, or attempt to aid another person in the planning or commission of an offense. An offense could be any number of things, from a murder to a robbery, a burglary, battery, from very serious to lower level offenses. The state or the prosecution merely just has to show you were involved and you helped in some way, or you knew about it and helped plan it in some way. That's not really a high burden. The classic example that we would learn about as attorneys in law school would be a bank robbery. You're the driver or the getaway driver. There's a plan in place, yourself and maybe one other person. It could be two or three or even more. And you come up with a plan that we're going to rob a bank. You're going to be the driver. The other individuals are going to go into the bank and actually rob it and take the money and run out. Well, with this theory of accountability or accomplice liability, even though you never enter the bank, your part is only to drive away. You never possessed a gun, you never entered the bank, you never did anything. You can be accountable or held accountable for everything that takes place in that bank. Meaning, if things went sideways and it wasn't just a robbery where they took the money and ran away, but in fact somebody was shot and killed and murdered and somebody else was pistol whipped and beaten or some other craziness happened inside, you can be held accountable and charged for having a gun, for an armed robbery, for a murder, and so on, even though you, the driver, you never even entered into that place. You didn't plan on there being a murder, but it's tied to this charge. It's tied to your plan that these individuals were going to run in there with guns and rob the place, and it logically follows that if you run in somewhere with a gun, things could turn violent and go sideways. So that is that classic example of what we learn about in law school as attorneys, about how you can be accountable, you can be an accomplice and be charged with the most serious crimes, even though you never held a gun, you never fired a bullet, you never actually entered that bank, in this hypothetical. And that's now true in every other type of offense we have in Illinois. If the state believes or they have some evidence that you participated in the planning or commission of this offense, and it could be as simple as encouraging someone to do it. Let's think of a low-level offense like property damage, that if maybe it was on video and they could see, or even worse, would be able to hear you say, throw that rock through the window or spray paint that building, and you're encouraging it or participating in some way. Well, you're as guilty as the person who threw the rock or the person who spray painted that building. And so that puts a heavy burden on that person who really has very little involvement in the case or in the actual commission of the offense, but they're as guilty as the person who threw the rock, fired the gun, or committed a burglary, or again, whatever that underlying charge might be. And now you're thinking to yourself, wow, what if there are text messages where I'm joking around with a friend and told him it was a good idea to rob a liquor store or to go and steal a PlayStation, or again, whatever kind of silly hypothetical we could think of, or even more serious hypothetical, if you're being sarcastic or sent a text or there's a voicemail encouraging someone to kill their spouse or their girlfriend for cheating on them, or again, crazy scenarios that you might find yourself. Well, there are defenses to the theory of accountability. And first and foremost, of course, is just saying, well, listen, I didn't aid, abet, agree, or attempt to aid this person. Like, listen, I had nothing to do with this. I had no idea they were going to do this. I'm not guilty because this other person just did something wrong and I didn't know anything about it. The legal phrase would be mere presence. You know, the fact that you're just there doesn't make you guilty. Now, it looks bad from the outside looking in. If you're present when somebody is shot, or you're present and there was a burglary, that's not great. It's certainly going to raise some suspicion and there's going to be some serious questions, but it is a defense. Just the fact that I was there doesn't make me guilty. But there are actually outlined within a statute, and I'm going to point you specifically to what that is. It's 720 ILCS 5/5-2. So ILCS, if you haven't watched some of our other videos, that's the Illinois compiled statutes, the laws of the land in the state of Illinois specifically. And that outlines that if you were actually a victim of a crime, you're not going to be held guilty. So you're there and you're actually a victim. You didn't participate. You've been injured. You're not going to be in trouble. If you actually were just doing something that was incident to this crime, again, you were present, you were doing something, but you weren't actively participating or aiding in this crime, you're not going to be found guilty. And then third, if you actually terminate your effort to promote or facilitate the crime and you took steps to stop it. So let's say you got very far into this process of planning whatever crime it is. Again, we'll use bank robbery for the sake of the example we'd used earlier. And you go so far as to say, you're telling your co-conspirators, these people you were planning with, I don't want to do this anymore. I don't want to participate. This is a bad idea. I don't want to do this. That helps, you know, if there are text messages and voicemails and emails or social media where you're telling these people, don't do it. I don't want to do this anymore. I'm not going to show up. I'm not going to help. I'm not going to play whatever role has been provided to me. I'm not going to do that. That helps. But the statute goes a little bit further. It says took steps to prevent it. So the state, the law, the police would be looking for you to have called the police, report this crime, report the bank robbery that it's about to take place, and warn the bank. Do what you could to actually stop things to avoid you being on the hook for the crazy things or the illegal things that your, again, co-conspirators, what would be a co-defendant, if and when charged, what they were doing. So that, again, puts a pretty heavy burden on someone who may have participated in a conversation about breaking the law in some way or making a plan to break the law. You have to take very definitive, specific steps forward to show that you're not participating and, in fact, you tried to stop it. So this is tough. This is an interesting part of law. I've had a number of clients who have been charged even with the most serious offenses because they were at the wrong place at the wrong time, or they sent a sarcastic text message that was picked up through the course of discovery, and they're implicated as aiding or abetting or participating in this case, even though they're not shown to be doing anything. They didn't pull the trigger. They didn't throw the rock. They didn't enter the building and commit a burglary. They're charged with the exact same offense as the person who did commit this offense, who did pull the trigger, who did enter and commit that burglary, who did throw the rock and damage property. So, you know, beyond the fact that I'm always going to advise that you don't break the law, certainly don't be aiding people who are breaking the law, because you can be held responsible as well. Again, I know this was a relatively short video. This is a complex topic of law. That's what I'm here for. You know, I want to answer those questions. Contact the firm so we can sit down and do a consultation and see how we may be able to help. If you enjoyed this video, we certainly want to produce more. We want to answer those typical legal questions, and sometimes in the count of this situation, like accountability, somewhat nuanced part of law, something that not everybody understands and is often misunderstood and confusing, and you're really kind of getting into the weeds of the law. That's what we're here for. This is what I do every day. I handle cases like this every day, and that's why I produce this content in videos, is to inform and to educate and to provide a service to those who have questions. Again, thank you for taking the time to sit down and listen to this. Hopefully you learned something. If you have any other questions, by all means, contact the firm, comment below, and we'll be seeing you soon. Thanks again.